Hello and welcome to everyone for our latest PlanWorks Power Hour. You might have come along to one before, but whether you're returning or this is your first time, we hope that you're going to find this session useful. Just some ground rules to cover before we start. You might have seen this already. We are going to be recording the session and it is going to be available on our YouTube afterwards. So if you want to go over anything that we've talked about today or want to pass it on to a colleague or friend that you might find it interesting, feel free to. It's going to be an interactive session, so please ask away any questions as we go through the session, as they crop up or as we're talking about a certain part. Use the Q&A function to ask your questions as we go through, and if we don't get round to them during the session, we will follow that up by email. So going straight in, we are joined today by Ben Osborne of Kinherit, and I'm going to pass straight over to him to talk about maximising value through estate planning and collaborating with introducers. As I said, if you've got any questions, put them in the Q&A. I'll come round to them. So welcome, Ben.
Thank you very much, Sean. Lovely to be here for the PlanWorks Power Hour today. So today we're going to be going over quite a few topics. So just going to introduce myself. My name is Ben Osborne. I'm a senior estate planner here at Kinherit. So we are pioneers of what we call end-of-life planning. So we have some really unique ways in which people can plan for going through life in various different ways, which I'll go into detail later. I've been in and around the industry for almost a decade now, and plenty of experience dealing with a variety of different clients and professionals such as yourselves. So today we're going to be having a look at kind of a full breakdown of what we consider a will, some trusts, some things to look out for, certainly in relation to lasting power of attorney and business relief. So number one, we're just going to make it really simple. What is a will? Ultimately, a will tells you where you want your estate to go. So if you were to pass away, you name some names and they are going to attain absolutely. Now, it also states who you want dealing with your affairs. So you can pick individuals who will manage everything. They'll deal with the legal process of sorting out your estate. This will be things such as your funeral, liaising with friends and family, and maybe dealing with things in the home. And lastly, maybe for younger individuals or people with minor children, it's appointing guardians. So you can specify who you would like rather than leaving it up to the courts to make that decision. Now, without one, what can happen is quite drastic. So number one is the rules of intestacy determine where your estate goes. So the government has a very clear table that very clearly states where your estate goes without a will. Now, this might be to your spouse, civil partner, then to children, parents, brothers, sisters, uncles, aunties. Eventually, if it can't find an individual who would inherit, it's going to go to the state. Obviously, a lot of people want to avoid that from happening, so it's really important that even for that basis, a will is considered. It also states that the court will appoint who is to manage your affairs. Now, this might be someone who they feel is adequate to deal with your affairs, and maybe they might not be best poised for that. Certainly with regards to personal wishes like funeral, they might not be followed. Might just be the cheapest and easiest option for that individual, especially if they don't have a good relationship with you, but might be the closest relative. And lastly, guardians are appointed by the court. Not only is this more of an impersonal appointment, actually one of the issues is that from the practical point of view, those things might be considered. Met with many clients throughout the years who would consider very close friends rather than family to look after their children, maybe because they have that good relationship. Courts are maybe less likely to go through that option, and so therefore, because the guardians are appointed by the court rather than your will, it's something that they could be stuck in social care for a period of time before actually being able to speak or even see family. What is a trust? Now, the trust is different. It offers protection. Where we have the will before, a trust helps to offer protection in a positive way. It's flexible control. That flexible control really comes from the testator, the individual who wants to create that will. So you can decide on how you'd like your will to, and your assets to be distributed. There's many different ways in which we can look at that. And ultimately, one of the things that we really, really strive for here at Kinherit is that generational protection. We're not just protecting our client, we're protecting our client's children and children's children and so on and so forth for the future. It might not be children, it might be nieces, nephews, it might be other family. But ultimately, we're looking at protecting that inheritance best as possible. And there's a couple of scenarios here that I'm just going to flag as kind of key reasons of maybe why we might consider a trust. So, for example, got a child who marries here. They end up inheriting from your standard will, but end up getting divorced in the future. So, what happens there? Maybe the individual passes away, they leave everything to their wife. Their children will attain after that. But then our wife or even husband remarries during their late life marriage. What happens to the assets then? Maybe, in fact, the survivor actually goes into care. They own the whole house now and they've gone into a care home. This house is their key asset. It's the asset that they've worked so hard throughout their lifetime to pay off the mortgage and keep ready for the children. But then the survivor has to go into long-term care, permanent care. What happens then? Maybe an individual goes bankrupt. It's very easy in today's kind of economy to pick up that credit card or take out finance and forget about those payments. If something happens in life that means that they can't be paid anymore, and if they inherit a load of money, then what happens then? And lastly, the children inherit, but they pass away. What happens with their estate now? Do they have a will? Was that something that they anticipated? Now, all these kind of questions can be helped by having a potential trust within your will, within your planning, to protect against these circumstances. It's there for that protection element. And it's depending really on a client's circumstances, on what they're looking for. I can guarantee everyone in here can probably look at one of these examples and say, oh yeah, I've seen this happen, even in a client scenario, maybe your own scenario. And really, one or two might resonate with you. All of them might resonate with you. Hopefully not all of them, but maybe one or two. So there's a difference between the wills and trusts. So what are our key differences? So when we're looking at the two, so you've got your standard will. A standard will, as I mentioned before, gives absolutely, there's no protection. If you want to give £100,000 to an individual, you can give them £100,000. Can't state what they spend it on. They get it, they can book their next flight to Vegas, that's up to them. They can take that with them. Very little flexibility. You can try and put conditions on attached to those sums, but again, it's very, very limited. It essentially says three things: where we want our estate to go, who we want dealing with the affairs, and who we want to look after the children. Any kind of further planning points that we would want to consider are very unlikely to be honoured or be able to be included in a will. A trust, however, has generational protection from many threats. So the threats that we've already looked at. It's also very flexible. It's control, but in a positive way. So we're helping to protect the assets for the future. So these threats to wealth are divorce, remarriage for an individual. It's care home fees, really huge certainly at the moment, even with the changes in reform, something that is definitely on a lot of people's minds right now. Bankruptcy, and that generational inheritance tax. Just want to clarify a little bit more what we mean by that. Now, discussing with clients, of course, performing due diligence to understand a little bit about their circumstances, to understand, okay, well, this individual has an inheritance tax liability, or they're very likely to in the future. Well, if they pass everything to their children, maybe it's an only child, that individual does well themselves. In the future, they've had to pay inheritance tax on their parents' estate, and now they're sat in the same position to think, well, I've inherited all this money, now I have to pay inheritance tax. So you're essentially paying inheritance tax, larger amounts on sums that's already been subject to that. The trust is a great way to help to ensure that actually we're planning for that for the future, to ensure that that liability is something that they don't need to think of. And the real key difference here is the legal ownership and the beneficial ownership. We're not saying you can't have the assets. We're saying you can, but there's some protection behind it. There's reasons why we look to do so. So happy to answer any questions so far. If we've got any there, Sharon, any questions so far?
No, nothing so far. No.
Good. So one thing I mentioned there was the importance of due diligence. Now, why is it so important? It's ultimately there to know, we need to know our client. So we need to know their circumstances. I've come across so many different scenarios where, for example, even in some, you ask, do you have children? No. well, I do have, a son or a daughter, they're over 40, I don't really consider them a child though. Okay, well, we ask some questions to understand and go a little bit further to appreciate that from their point of view, they may not be releasing information that they don't think is relevant. But by asking the key questions, by going through and understanding more about their scenario, it helps me, for example, and the other qualified estate planners within the team. It helps us to provide them with options that they may wish to consider for their planning. Maybe they own a property on their own. They live there with a partner. Their standard will is not going to help to protect against that partner remarrying in the future if they leave the property to them. I've got some kind of key planning points that we can look at later on in this seminar today. But that is one of the things that, certainly would be revealed on the questions. So what questions do we ask? Again, so we are trying to understand a little bit about their circumstances. Maybe there's some specific business assets that we need to consider, whether they're AIM listed shares, or maybe a small family business. Okay, well, if we ask about the family business, how are you looking to leave that? Is that something that you want to keep within the family? We can look at specific planning. Again, a little teaser, that is something I will go into a little bit later. But these kind of questions are poised, and it's important within all areas for yourselves, for us, to understand that we need to know and understand our client. That's the key. We need to know their circumstances and understand why they're looking to do what they're trying to do. It's all well and good just trying to take an instruction. We don't know more about their circumstances. It's very hard for actually to really provide sufficient options. And that's what's really important from the point of view of using Kinherit, for example. Now, the will writing industry is unregulated. There's no regulation. And really, it's such a big risk. Anyone can write a will, state that they're a will writer and prepare wills. The amount of wills that have come through to me to perform, we undertake free will reviews for clients so they can be certain of their circumstances. They can understand what their will is likely missing. And there's been circumstances where will writers have not considered certain options. They've not considered legal terminology. They've included things like punctuation, and all of these things can actually lead to ambiguity and not following wishes correctly. And the thing is from that point of view, in the future, if there are issues, these beneficiaries are going to say, well, I'm going to try, I want to talk to this will provider. Why did they write it like this? And if they can't, they're going to talk to the person who introduced them. And they're going to say, why did you put faith in this company? Did you not do your own due diligence on this company? So even then, from the point, it's not just knowing the client, it's actually knowing the companies that we work with and the people we talk to in a professional setting. It's so important from every aspect that understanding so much more, we can then look to spot things. And a lot of clients, a lot of the time when we do and take these free will reviews for them, they're made aware of options they had not considered before. Really, really important. Now, the due diligence aspect certainly goes on to how property is owned. Now, obviously, as I mentioned before, a lot of buzz about the care home aspect. Property ownership kind of goes hand in hand with that. Now, we've got two key ways in which that two individuals or more would own a property. So we've got joint tenants and tenants in common. So joint tenants is where property will pass automatically to the surviving owner. Doesn't matter what the will says. We can say that we want our house to go to the dog's home. Doesn't matter. If it's owned as joint tenant, it will pass via survivorship. It will pass regardless of what our will says. In some circumstances, that's okay. What that means, though, is that we lose potential protection through trust. We lose other protection to highlight that there are two distinctive shares, which is what tenants in common does. Tenants in common very simply states that I have carved out my own share, say 50% each. That doesn't mean, obviously, that clients might own certain rooms in the house. They can still continue to use the house as they like, but they've got two distinct shares, and their share will pass via the will. So before it goes anywhere, it will say, well, what does your will say? Where does the will want me to go? Now, if we're looking at that greater trust protection, great, that can go into the will. So let's have a look at the power of the trust. So the real key power of trusts here. So in this kind of little scenario, I would say myself and my wife, and I've got a child here. So I've sadly passed away. I've passed away, and we have a couple of unsavory individuals here. So we have Steve. Now, Steve is looking to hopefully marry my now widowed wife. He's come in and seen that I've left quite a lot of money behind. And in my standard will, it's just all left to my wife. Now, she gets married to Steve. Then what's left for my daughter? Son, in this case, either. Now, there's Dave. Now, Dave is married to my daughter in this case. I've never liked Dave. I really despise Dave, actually. And he sat there thinking, well, one day that money's got to trickle down somehow or somewhere, and I'll be there waiting. As soon as that money's then with the daughter, then it'll be a case of, well, I'll file for divorce. Let's have a look at getting some of that money. That's all he's in it for. Then we got Roy. Roy works for HMRC. He enjoys having a look at large estates and ensuring that they are paying the correct inheritance tax. Now, passing everything via that standard will means that it's in the individual's personal estate. If I passed away, even if I passed it all to my daughter in this case, if she then passes away, Roy said, well, you paid inheritance tax before. Unfortunately, your estate's high enough that you're going to be paying it again. Then lastly, Carol. Carol works for the local authority, left the home to my wife so she can live in it, has that security for her lifetime. Unfortunately, she's been diagnosed with some various illnesses, which sadly mean that she can no longer look after herself. She's had to go into permanent care. In that sense, now Carol then has a look at the value of her estate. The whole home is now in her name because I've left it via joint tenants, I've left it via survivorship, or I've just left it in a standard will. So she's going to say, well, unfortunately, there's no more cash left. You're going to have to sell the home potentially and look to pay for care. The level that's left is very low, approximately 23,250 at this current time. So that can kind of diminish an estate quite quickly, quite rapidly. So instead, let's have a look at the trust. So how is the trust protecting our assets? Change the property to ensure that we've got the property as tenants in common. And now that half goes into the trust. We say that the property is the key asset here. Our wife, our spouse, our civil partner here, they can still live in the property because we've made that provision. They can live there, they can downsize, they can release capital from it and enjoy the money. That's fine. We're not jeopardizing their position at all. But if Steve comes along and remarries or marries our widow, that half of the house is protected. I've already protected it. It's in trust, and it's guaranteed to then follow suit to go to daughter, son, child in this case. Dave, anticipating that, half of the house coming to him when he, files for divorce. Now he's gone through that divorce proceedings, and now he's quite surprised to know that actually the house isn't in, our child's name. Actually, it's in trust. It's for a benefit. But we don't want any kind of benefit to be released until those proceedings have been finalized, until it's, there's no financial obligation left, if any. That decree absolute has been granted. Now she can start to get a step up in life and utilize those assets we've left behind. Roy at HMRC, through the trust, we're not concerned regarding, our child's kind of inheritance tax position now, because although they might have their own estate, the inheritance that's left behind for them is there, it's protected, and it ensures that her own planning is just on her primary assets. So she can still benefit from them, but maybe it's the case of utilizing that throughout her lifetime in an income stream rather than taking the house entirely. Lastly, Carol. Unfortunately, our widow has gone into care, but she only owns half the home. She doesn't own the whole thing. Though she has the benefit, the legal ownership for half remains in trust. So in terms of the liability to pay for care for the whole home, half is therefore then protected. And we've done that as part of our end of life planning. There's so many different circumstances and why we're looking to do it. These are some of the examples. Doesn't cover completely all of them, but these are very common examples of something that can happen day to day. And I'm sure, as I mentioned before, that everyone can at least relate to maybe one or even two. So all those kind of concerns that we've discussed, those threats are diminished all through because we've had the appropriate planning early. We've had the appropriate conversations early. We've gone through those potential circumstances. Most clients I speak to on the day, on day to day, they will usually prompt and mention one of these things. They'll say, well, I've now experienced this because my parents, they had to go into care, I lost a home. Or they've said, one of my friends, they got married later in life, they've lost, very large sums of money because of those circumstances. The trust is there to protect people. There to protect people. It's not a negative level of control. It's there to help. Now, is there any questions just to cover on that one, Sean?
Yeah, so you've talked a bit about protecting the home, especially from care home fees, which is a really, really common scenario discussed by clients most often. But obviously there are some solutions out there that offer to kind of, I know we're talking about end of life, but during life, there's lots of solutions that kind of say, put your house in trust and protect it from care home fees. We're all very careful about that in our profession because, that's not we don't see it as necessarily a good reason to make certain plans like that. But do you have general feelings about that? Do you get involved in things like that, or are you just end of life will planning?
No, so it is certainly something that we do get involved with. So in terms of kind of lifetime planning, certainly when let's look at the property, for example, maybe protecting that in a form of a property preservation trust, or a trust in lifetime that protects that asset. Now, that's not without risk, because there's so many different factors we need to look at. And it's, again, back to this due diligence, really, is understanding the client's scenario. Why are they looking to do it? When are they looking to do it? If they're late life elderly, they've been diagnosed with with some illness, going through that kind of route of planning is very unlikely to be successful, truth be told. And the reason is because essentially when they get to that stage of assessing the home, they're going to be looking for one thing, and that is the potential for deliberate deprivation of assets. So and this applies to money, this applies to the property, has the planning that the individual done, is that something that they could foresee that they might need to go into care? Now, done early enough or done with no sign of illness, either physical or mental, any anticipation of care can be an option for clients. It is certainly something that we discuss. And it is very specific to their circumstances, though. So it's not something that we would recommend as a kind of, certainly not a cookie cutter approach. And that's not the way that we approach any of our planning. Again, as we mentioned before, the unregulated status of the will writing industry is a real key problem. And I think I've seen quite a few wills, certainly from maybe similar providers, and you get this kind of cookie cutter approach in their wills, and you see the same kind of writing. It doesn't work for everybody. So everyone's scenario is different, and understanding that. We do also work with professionals who can assist with kind of more specific scenarios with regards to professional executor services and trustee services. So yeah, absolutely. The lifetime planning element is really key. And certainly with regards to when they're looking for that lifetime gifting element, maybe chargeable lifetime transfers, it is something that I'm certainly aware of and aware that clients might benefit from. And it's identifying what's right for them and to assess those options at that time. So absolutely, it is a potential option for clients. The wills is the focus, because it can really help just to capture whatever assets are there should that individual pass away.
Perfect. Thanks, Ben.
That's okay. Yeah, no worries. So I'm just going to talk a little bit about the creation of the right handover. So one thing that's really, really key for us at Kinherit is the inclusion of something called the Kin Vault. Now, our website contains a very comprehensive video, only 60 seconds long, of what the Kin Vault is. I couldn't embed it into the point today. But what it essentially is, it's a online vault. So it's like a digital vault that backs up your will. So imagine the box under the bed, if you like, but it's all online. Our clients receive this free with all of our wills, and it helps to give information such as where important documents are located. It helps to provide things like who are utility providers, some details about the property. It helps to ensure, what are the financial assets here? So what kind of financial assets do you have? What kind of pensions are there? Who are the pension providers? Maybe keeping a track of any investments. So you look at shares that might be invested in, keeping a track of what kind of values they are looking at, and it helps to show a progression of how that might work. And they could create reports on that. It's a great tool, but it also allows individuals to know what to do. So to kind of give an overview, of some of the great pieces within the Kin Vault. So I use it myself for usually kind of renewal reminders. So I stored information about where some certain gifts are within my home. I've used it for renewals on all my insurances. So all my insurances, I've got my providers on there, when they're going to renew. So I get reminders so I can go in and I know to shop around on the market to find the best product for me. Now, other clients might find the more useful side for them being keeping track of their investments, updating their funeral wishes, leaving videos and pictures for their loved ones. There's so much information that they can store, and it's at the click of a button that only they have access to. The idea behind the Kin Vault is that it's there designed to make that role for the executors so much easier to do. It's so common, and in previous roles where I've had executors come in and say, I don't even know where to start. I don't even know where to start. I don't know where anything is. I've only got the keys to the home. I don't even know where to start. And that's a real traumatic kind of period for an individual. They've just lost a loved one. They're in a very vulnerable position. And so for us to be able to provide some useful information for them that clients provided for them, provide that should they pass away. We have a very unique process of how we reach out to people towards the end of our will signing process. Such a common question is, well, how is anyone supposed to know? How is anyone supposed to know I made a will with you? We reach out to those trusted people. We reach out to them to say, we're Kinherit, just so you know. You need if you have any questions, you need any details, feel free to contact us and we can help with that kind of transition in the future. It gives clients so much peace of mind so that they are certain they know what to do in that instance. It does provide a lot of relief to people. So the Kin Vault is a really good benefit to the planning. Now, talked a lot about the kind of end of life. Very rightly so, Sean mentioned before, there's some lifetime planning aspects as well, and lasting power of attorney is super important. Now, Martin Lewis, a lot of people love him, a lot of people don't, but he's very recently provided great guidance on really when people should be looking at their lasting power of attorney. So when did he say? As soon as you turn 18. As soon as you turn 18. And I agree. 100% agree. Once you hit that stage, as soon as you're an adult, there is no legal next of kin. The husband or wife or civil partner, they can't make decisions for you. So it's so important to review those circumstances at the time and appoint those individuals. So there's two different types of lasting power of attorney. So you've got one for property and financial affairs, and that'll be dealing with things like direct debits, dealing with banks, utilities, property itself, standing orders, withdrawal of cash, day-to-day things. And then you've got health and welfare. Although that might seem more positioned towards end of life care and things, it's not. It's also to do with life-sustaining treatment, resuscitation, but it does extend to decisions about care as well. So there is that kind of element that a lot of people think, well, younger in life, property and financial probably more tailored for me, health and welfare maybe later. I do disagree with that, because if you know what's going to happen to you tomorrow, then take that approach. But it's important to have both to ensure that you're protecting yourself in any such circumstance that might happen in an instant. And we can't predict when that might happen. Now, without them, there are some processes that can help to be rectified. One of them is, or the main one is deputyship. It's a very complex process. It's a very expensive process. It's a very long process. It's something that is to be avoided where possible. And it's kind of the retrospective way to obtain similar powers. Now, the problem with it is that all during this time, you can't make decisions. So no decisions are going to be made. So seeing loved ones, likely to be very close to you, and seeing, not being able to talk to the bank to get money out for them to pay for certain elements of care, or maybe just to go out and buy food and clothing and things like that. Those simple day-to-day actions that we might take for granted become a whole, completely difficult for clients to undertake. Can it be rectified? Yes, it can be rectified, as I mentioned before. It can be. However, again, it's the delays that cause the issues. is the delays. Even so, I've had many a client unfortunately approach and say, well, I've just been diagnosed with early stages dementia. Okay, I'd like to put lasting powers of attorney in place. Okay, the registration process with the courts at the moment is around 6 months. So depending on how rapid that acceleration is, the way to expedite is very difficult. But not only that, but it's very likely at that point you're going to need medical, a client's going to need medical reports to prove that they're of sound mind, because you can't put the lasting power of attorney in place if you are not of sound mind. That can prove really difficult, again, of cost to obtain medical reports. So doing that proactively, lasting power of attorney can be very much akin to how insurance would work. You sign them, your attorney signed them, all sent off to the Office of Public Guardian, the courts who register the documents for you. Once they're registered, you can put them in the drawer, put them in our secure storage if we help you put them in place. And then they're accessible at a moment's notice. Okay, I need to use these. That's fine. They're there. They're there ready to go. They're there ready to go. So it's super important. Now, I do mention there is potential business property and financial affairs. Bit of a spoiler, but I will be coming on to that now. So just before I do start that business relief, I do want to open up just to see if there's any other questions there. Sean, anything else, obviously, I can clarify about lasting power of attorney.
Yep, you've sparked a couple of questions that have come in. So, so I don't know whether this is very common, but letter of wishes, we normally see that with putting a trust in place from the settlor to the trustees or beneficiaries. Is that common with a lasting power of attorney? And if so, what sort of things would you expect to be in a letter of wishes that goes alongside a power of attorney?
Yeah, 100%. What a great question. Yes, 100%. So for individuals where you are looking for that lasting power of attorney, now these might be attorneys who, for a lot of circumstances, it might be children or husband and wife, not going to know day to day, what you do in terms of a routine, what you like. And I've helped to prepare clients for if they did lose capacity. I boiled it down as little as, my favorite dinner is this, my favorite food is this. I enjoy listening to this radio station. I enjoy listening to this music, because if there is that lapse in capacity, it's still that same person, and you want to honor some of the things that they enjoy, the hobbies that they enjoy. I always watch my favorite team on a Sunday at so and so. So leaving these notes to ensure that these kind of wishes are honored and are followed really adds extra depth to the planning for clients to understand a little bit more about, well, are they going to know that I like to do these kind of things? And even some of the silly things, sometimes it's just watching cartoons on a Sunday or something. Everyone's got their own kind of things that they really enjoy, and I think leaving those kind of notes on how you'd like those matters to be dealt with is really important. So the personal matters, but you can also, again, it goes down to the kin vault. You can leave these kind of wishes within the kin vault to make it easy access if needed for these specific wishes. It might just be the case that for your attorneys, knowing where some certain items are, in terms of, well, if you need to contact my banks, I deal with this bank, and this bank. And just that kind of initial information can be really helpful. And maybe proactively, an individual wants to provide their lasting power of attorney to their banks to say, just in case, you've got a copy. So if the individual needs to contact you, you've got everything you need. So great question. Yeah, good.
Perfect. And following on to that, I've got my own little question as well. So obviously on the kin vault, you can put specific requests on there, bespoke information, I guess. Now, would you suggest, do people put passwords on there for things, like passcodes for phones and stuff? I'm guessing you might say that's not a good idea.
It's always a difficult case to say whether you should be storing passwords and things, because passwords shouldn't really be written down where possible. From a security point, there's no issue with the kin vault. It's held on servers akin to protection that NASA would put in place for their servers, so very much akin to the same level of encryption and complexity there. So from a security point of view, there's no issue. However, of course, there is the practicality of storing passwords and typing.
Personal decision, maybe.
So it is a personal decision, absolutely, yeah, of course.
Perfect. And then another question on for LPAs. So if a client has signed a pre-2007 EPA, should they now replace it with an LPA if they're still young and have capacity?
100%, absolutely. Now, the enduring power of attorney, replaced in, as you said, 2007 October, only deals with financial affairs. So we've got no health decisions there. Now, I have personally assisted clients in the registration of the enduring power of attorney, and it's a bit of a backwards way in which it's registered. So what happens is you can only register that with the court once an individual's lost capacity. Now, there's a process in which you have to notify various family members. You have to wait for them to either hopefully not refuse consent, but there's a 30-day window. Then you have to go and register them with the Office of Public Guardian. All this period of time, that you can't make those decisions for the individual. So it's almost like not having anything in place at all for that for weeks and weeks on end. And it just makes things a lot more difficult. This is kind of the flip to register them early so that they're ready to be used when needed. So from an access point of view, 100% should look at replacing them. We pride ourselves on our competitive prices for the lasting power of attorney and the ease of the service that we do for this. There's no, a lot of clients love to tag this on to their will planning because it just makes sense to wrap that up at that time. So yeah, 100%. If enduring power of attorney, they will serve a purpose, but there's a much better way to deal with that.
Absolutely. And then final question on LPAs before we move on. Does having the expression of wishes in the LPA help expand on end-of-life decisions?
It can do, yes. So there have been circumstances where you can include wording that might state, for example, if you are in a position where your quality of life has dropped significantly, you can put wishes to state essentially a do not resuscitate. So for no resuscitation, allow that decision to be known to your attorney so that if doctors do say, we're happy to provide life-sustaining treatment, we're happy to resuscitate, they can state that decision, say that's not in line with this individual's wishes. Very clearly state that. So that is something that we do not wish. And some people do have that view, and that's absolutely fine to include.
Cool. And then just expanding on that, just for my own knowledge, because I've got a bit of knowledge in this area. Like you said earlier, you have family or personal experiences in these kinds of things. Do you, when you go through the process of putting in place a power of attorney for an individual, do you talk about kind of those resuscitation decisions? Because most people wouldn't, unless they've know somebody that has gone through that and had to make those decisions in real life, they don't really understand that the impact that resuscitation can have. So do you kind of have some education piece around that with the people that you do this with?
Yeah, absolutely. So what it is understanding that the client is aware of the circumstances surrounding the resuscitation. So of course, from the medical point of view, I can't advise on exact. However, to understand that the choices are given to allow the flexibility for your family to decide on what they feel is best. Now, medical professionals, doctors, will of course provide their opinion at the time, and they're very good usually at listening to family for their decisions, even if an individual on their lasting power of attorney wants to leave that decision to them rather than their family, and that's absolutely fine. And what I discussed with the clients is to state that if they don't have a strong view, understanding what scenarios it might be that might allude to. So maybe it's a very serious, heart operation, triple heart bypass, or maybe cancer treatment, to understand that there may be circumstances in which the quality of life following that may drop. Of course it's not a nice thing for individuals to think of. None of these conversations are, but it's boiling down that we're having this conversation to help protect against these things from happening. So it's in their best interest to understand that, and of course I'm more than happy to guide clients through that process so they understand a little bit more about that.
Yeah, absolutely. Great. Thanks, Ben.
All right. So if we just move on to the business relief side of things now. Now, business relief has been around for quite a while, and there's several different factors. So we're going to look at now what business relief is. We're going to look at who it applies to. We're going to look at why we look to apply it. That might seem obvious. And lastly, how would we do that? So what is business relief? Business relief essentially reduces the value of a business or its assets when working out how much inheritance tax is to be paid against an individual's estate. Now, it is potentially a business owner's best friend. There's a lot of individuals who might have come across in your time who you can think, well, their business is, scaled very nicely, but it kind of dwarfs their personal estate. So it's really important that we understand a little bit about the business relief side of things and how it impacts an individual's estate. So who or what can obtain business relief? Now, the key here for an individual is they must have owned that asset for at least 2 years. The 2 years period of ownership. Now, there are some certain rules with regards to quick succession. I won't go into too much detail because it is usually a case-by-case basis on how we look at that, but 2 years is kind of the key period of ownership for those assets. The percentages are kind of split into two. So 100% and 50%. So 100% might apply to shares in a listed company, shares in a company listed on the alternative investment market, so AIM listed shares, and a business or interest in a business. And 50% may apply to maybe some physical assets such as machinery, plant, property assets, or shares that control over 50% of the voting rights in a listed company. Now, just to kind of provide some context onto what that might look like on a real life scenario. So if I own a printing press business, my printing press business just prints things for you. You send me a PDF, I'll print it for you on nice paper. Now the shares in that company may apply for 100%. They may apply for that, but I also own a building. I own the building which I need to print things. I've got a printing press, so we're therefore potentially looking at 50% relief for that side. So that kind of puts it into context on what we're looking at in terms of those different percentages. Now, 0% would be due on businesses that mainly deal with securities, stocks and shares, land or buildings like buy-to-let portfolios, and the making or holding investments. It's really important to understand, certainly with kind of group companies, what their kind of arms of business look like when deciding whether business relief is applicable. Now, non-profit organizations will have their own exceptions. So qualifying assets are all that's needed. Is that right? Wouldn't put the slide in if it was. Of course, we need to consider the legislation. So section 39A of the Inheritance Tax Act helps to govern business relief. It's a long piece of legislation. However, if we do not have the correct planning in place, the relief may not be used as intended, could be wasted. And we're going to have a look at an example of how that happens shortly. There is a difference at the bottom between kind of two different values here, and I'll go into that shortly. So why would we add this to the planning? Now, relief can be wasted where we've got a difference in beneficiaries. So essentially we have a difference of non-exempt and exempt beneficiaries. I'm sure we're all aware of, for example, spousal exemption, or providing part of our estate, or all of our estate to charity, where that is mixed in line with non-exempt beneficiaries, so such as children. That's where the issue kind of comes in. Before I go into the example, just wanted to see if there's any questions there. Sean, so far are we all good?
Only from me. I got just a question about business relief. You might well cover this anyway, but when it comes to whether an asset qualifies for business relief or not, or at what level it qualifies, is it someone like yourself that we would potentially come to, or the client would come to ask that, or is there someone else that we should go to? Normally we would head them off in the direction of an accountant.
Absolutely, yeah. So accountant is the so absolutely. So to determine that, it's not something that I can do, unfortunately. An accountant should be able to assess the exact of the business itself, depending on what the assets are, of course. It might be a little bit easier with AIM listed shares, for example, but compared to kind of a fully operating and a trading business, it's something that an accountant would no doubt be able to assist with. So I'm more than happy, through the remit of my role, to liaise with accountants, certainly with regards to timing, planning, because their lifetime planning can accept or can affect what we're looking to do.
Great, perfect.
So here's the example. So myself and my wife again. So here I've got a will. Now, just to make this really, really simple, the £900,000 value of business here is fully relievable. So 100% business relief. We're just going to make it really easy. The £1.1 million is just cash. So I'm just going to make it really easy in terms of calculation. So my estate, where she was around about 2 million. Now I've passed away. And my will is very simple in its nature. So I'm going to provide £600,000 to my spouse. Now my spouse here is receiving benefit from life insurance. They also receive the benefit from my pension. So I've got a SIP, which are the nominated beneficiary. So I don't want to provide her absolutely everything because she's getting a great deal. However, I'm going to leave the remainder to my children. Now, my children have made quite a big interest in taking on the family business. They want to take that on in the future. If I leave them the lion's share here, then no doubt the executors will just wrap that up as part of the business and they'll get some cash as well. Now, it's assumed we have around about £70,000 in terms of inheritance tax bill because we've got spousal exemption. We've got a nil rate band, currently of £325,000, and the full business relief. That's assumed. However, not what's actually happened. So what's actually happened is that we've lost business relief in proportion with the estate. And the very simple reason behind this is because we have not allocated our business relief. Instead, it's applied itself against the whole estate. Now, to break that down into a little table, what's happened is primarily the top middle box. What's happened is because 30% has gone to our spouse, we've lost 30% of the spousal exemption there because, or 30% of the business relief because it's applied against the share that's going to our spouse or civil partner that would have usually applied for spousal exemption. So we haven't told business relief where to go. Legislation very specifically states we need to tell it where it needs to go. And if we don't, in these circumstances, we would lose some of the relief. If we say that the split is 50-50, we're losing 50% of the relief. So it's so important to help to consider the specific planning. And before I kind of go on to the example of, well, how do we rectify that? What kind of flagged the issue for us in the lapse of knowledge within the industry is drawing a very large kind of will review process through assisting a provider. 102 wills were sent over to us. All business owners, only 2 of them had appropriate business planning. There's a lot of phone calls to make. There's a lot of letters to write, maybe a couple of apologies as well. So for that independent provider, it's a lot of work for them to then go back and try to rectify, because without that appropriate planning, quite a few issues that would crop up. But of course, it's good that we could deal with that. So how do we fix this? Again, very much similar to earlier, the trust is always an option, but you could also stipulate a clause, so a clause that takes into account the legislation, Section 39A of the Inheritance Tax Act. Isn't just a case of saying, I give my business, we do want to apply specific provisions. Yes, we're getting that business relief. Yes, it's tax efficient for the first individual for their business relief side of things. However, when they pass on that asset, the second individual is in the same boat. They then have to review their planning. So there's no ongoing protection for beneficiaries. Now we look at the trust. We are there again, pretty much all the same protection pieces that we discussed before. However, there's one tagged on at the bottom, which I do like to highlight, and it's that control after death. Really important is that maybe, for example, we've got a business that the children are looking to take on. Maybe they're not in a position, maybe they're not mature enough or experienced enough to run that business. So let's look at the trust, ensure that it's there, can be managed until such time they're ready to take it on. That can be done then in the future. Of course, again, it goes back to that due diligence factor, asking these questions to understand, what's your 5-year plan? What's your 10-year plan? What's your plan for your business? Because it's such an important part. And it's only through the right questions that then that information is revealed to say, well, actually, have you considered this? Have you considered that? The con for this is that it is a minor additional cost for our planning in terms of including it within the wills. The great thing about Kinherit and what we do, we don't hide any of our costs through any kind of walls of information. Provide us with all your details, then we'll give you the cost. It's all available on our website. Clients are free to have a browse. You're free to have a browse. That's what we're very transparent about that. So here's a solution in practice. We've got the same scenario, same estate. This night I passed away again, but this time I specifically made a provision in my will for my business. Now, whether that's via the clause, I'm happy for them. They're in a position they're able to take it on, or via the trust. Instead, we have this scenario. So got the spousal exemption there, that's fully applied. Got our nil rate band. And lastly, we have the full business relief that's been applied. So rather than that difference before of that higher inheritance tax that we didn't anticipate, there's £108,000 difference in this case. As I mentioned before, they might try and approach the will writer for the incorrect planning, but they'll also approach the individuals or the company that referred them, because they'll want to know why was this not picked up? Why would you refer to someone who doesn't know this? So to guarantee the relief, there's three things. Number one, qualifying business assets, usually where accountants, financial professionals are looking to assess the business to understand that, yes, it does have qualifying business assets. Must have owned it for at least 2 years. And that's kind of up to them, up to the clients. We can't really control that on how long they own that business for. Lastly, which is more relevant, the clause or trust. 99% of the time, the trust is going to be a lot more beneficial for clients for that future planning. It's not always the case. Sometimes they are just looking to guarantee that they are benefiting from the relief. However, that is something that we would discuss with them. Now, before I just open up to the final questions, there are 2 additional points of planning which we do find really useful for business owners. Now, number one is a cross-option agreement. Very simply, a cross-option agreement is the potential for business owners, usually a couple of business partners, they don't have anything in place, and their thought is, well, if they pass away, then their shares will go to their family. That's fine, because that's what their will says. Maybe they don't want their family coming in and potentially making business decisions. Maybe that's not the best way for them to do that. So the cross-option agreement says, okay, well, let's have a document that says those shares can be bought by the company for the value of an insurance product that pays out for the value of the shares. And they've got the option to facilitate that that transaction. Now, if they don't exercise that, that's fine. Maybe the family don't want the shares. Maybe they'd prefer the payout of the policy. So they facilitate that. Gives an option to both parties. It's really important that it's just an option, not binding any party to a contract for sale. Just lastly, the business lasting power of attorney. It's just a property and financial power of attorney. However, for some clients, they may be happy with their family dealing with their personal finances, but their business finances may be a different matter. Certainly, if they're within a regulated market, they may want professional individuals or individuals who have that background, who have that regulated knowledge to ensure that any transactions they are facilitating on behalf of the individual are in line with regulated practices. It's a super important option. Actually, a lot of business owners aren't aware that you can split them. So it's something that we do discuss. And again, just falls back to that due diligence aspect. So really important piece of planning. A lot of clients kind of jump at that opportunity to discuss those further bits of planning. I appreciate that is quite a lot to take in today. Of course, I'm happy to answer any questions that may have cropped up or you may have, Sean.
Great, thanks, Ben. No, that's been really helpful. And that very last point that you made, I'm obviously a business owner, and there's lots of business owners in this room as well. I wasn't aware of that, so that's an action point for me. We've had one other question come in. So going back to, we've talked about unregulated will writing quite a lot throughout the session, which is a really important thing to recognise, especially because we are, in financial planning, in financial advice and recommendations, we are in a regulated environment. So if can we just understand like a bit of the circumstance around what might, if anything, about will writing could be regulated? For example, if a step qualified solicitor was writing a will, would they be regulated by the SRA, or is this still an unregulated activity?
So solicitors will be, they'll be, of course, as long as they're registered with the SRA, they will be regulated by the SRA. So a solicitor is an option for individuals they may consider. Now, the issue with that approach is you go and see a solicitor, a lot of the times a jack of all trades. They might deal with wills as like a side product, something that they can assist with. Now, obviously, through STEP, Recognised Society of Trust Estate Practitioners, we are specialising in this area. We are, wills, trust, lasting power of attorney, my bread and butter. It's what I know. It's what I specialise in. So when you are looking for that specialist advice, it's kind of akin to the barber who was also a surgeon. Are you going to go to that individual who can do all those roles at this point in life? You're probably going to see different individuals who specialize in them. So going to that kind of general practice, you might not get the specialist advice you need. You might not get the specialist requirement that you would expect. And again, it goes back to that where they haven't got that specialism. It's then a cookie cutter approach. I'm sure they can put trusts in your will, but your trust is probably no different from someone else's, and it's all documents that are just copy and paste, and you don't get that personal element. It's not. Yes, it might do, most of the job, but it doesn't do the job that's right for that individual. So there is that solicitor aspect. Again, with the cost as well can mount up. So yeah, it's certainly something that clients need to be aware of when approaching them. It might seem easy, but easy doesn't necessarily mean right.
No, absolutely. And we know that all too well in financial planning anyway. Great. That's all the questions that we've had come in, Ben. So I'm just going to say, well, thank you very much, because that's been really, really useful. And I've taken away quite a few tips for myself and as well, like I said, an action point too. So thank you, Ben. And I just want to say to everybody that's attended as well, thank you for coming along today. And if you want to hear more about working with Ben and Kinherit, then please get in contact with me. I can introduce you. And as I said earlier, there'll be a recording of this out on YouTube as soon as I can make it available for you to catch up if you need to. So thank you, everyone. See you soon.
Brilliant. Thank you so much for your time. Thank you.
Thank you, Ben.